everyone. My name is Abhinav Lohia. I'm the Managing Director of Global Business Development at Golden Gate Global. Golden Gate Global is a leading EB-5 investment fund headquartered in San Francisco with offices in Chicago, New York, and Irvine, California. Today, we are joined by Brandon and Christian, who are leading attorneys in the EB-5 visa field, and I'll let them introduce themselves.
Thank you, Abhi. Good afternoon, everyone. Thank you for attending our webinar. My name is Brandon Meyer. I'm the founder and managing partner of Meyer Law Group, which is headquartered in San Francisco, California, with additional offices throughout the United States and the world.
Yeah, hi, everyone. I'm Christian Triantafillis. I'm a partner with Jackson Walker. We are a full-service law firm with offices throughout Texas. I'm based out of the Houston office, where I'm the chair of the Immigration Practice Group, and we're very active and experienced in the EB-5 field. So thank you for having me.
Great. Thanks for joining, guys. So let's get straight to it. Brandon, first up, let's just start with the basics. I know a lot of our attendees know about EB-5, are in the process of filing and everything, but what is EB-5 and what are the requirements to get an EB-5 visa?
So EB-5, which has been around since 1990 in its current form, is the fifth category of employment-based immigration, which requires an investor to invest either $800,000 into a project located in a high unemployment or designated rural area or designated infrastructure project, or $1,050,000 if the project is outside one of those three categories. The investment has to be sourced from clean sources, which is known as source of funds. And assuming that process is okay, and 10 or more jobs are created from that investment, it should result in permanent residence for the investor, one spouse, and all children under the age of 21.
Great. Thank you so much. And it'll be great if you can shed a little more light on job creation and also how the money is invested and the length of investment.
Yeah, so there's two different types of EB-5 programs. One's for so-called direct EB-5, which for all intents and purposes, that's where someone tries to set up their own business and get their EB-5 visa through that business. It's a little bit of a niche industry doing direct EB-5. I mean, it generates a lot of discussion, but the number of people who actually do it is very, very small. In the direct context, the investor actually has to create 10 35-hour-a-week W-2 payroll jobs for qualifying U.S. workers, which are U.S. citizens, permanent residents, asylees, refugees. So basically, the investor themselves doesn't qualify, neither do family members. H-1B is L-1s, not a part of that 10-job count. Under the regional center context, the job creation methodology is significantly different. Most of the time, it's based upon construction expenditure or revenue or all sorts of different inputs that do not require the project to go back and actually show live human beings on payroll in order to qualify. So what this allows is for organizations to do the pooled investments and larger projects, because they can take advantage of the much more favorable job creation requirements under the regional center program.
Got it. And would you agree it's purely an economic model? It's just input, output, you invest money, you create jobs.
Pure input output model, of which there's about 3 or 4 recognized by USCIS as being acceptable. So if the project at the end can prove the inputs that it said would go into the project, then in most circumstances, the job creation requirement has been met because the job creation was assumed to have occurred.
Got it. Thanks for that. Now, Christian, coming to you, we'll start with some questions about investor profile. What are you seeing where the demand is coming from? Is it from within the United States, outside? What's the country of birth of EB-5 investors?
Sure. Yeah, I mean, I still see people interested from all around the world using this program, but we are certainly seeing a number of those who are right here in the United States moving forward with the EB-5 process. Those individuals being in non-immigrant visa status like H-1B, L-1, E-2, and others, student visa holders as well. And many are from India, but we do also see others from China, Taiwan, Canadian investors, investors from Nigeria is another area where I've seen more interest lately. So it's still a worldwide used program, but we are seeing kind of increased interest over the last year or two from the countries I mentioned. But I would say right now the most active are India, China, and other areas of Southeast Asia.
Got it. Would you be kind enough to shed some, I don't know, numbers or percentage terms in terms of what you are personally experiencing?
Yeah, I mean, I would probably say, general interest, I would say 50% or more of the calls that I take and clients that I'm working with are from India right now, many of whom are right here in the United States, but also others who, are abroad, whether in India or the Middle East or the UK, for example. But there still remains a very robust interest in other areas of Southeast Asia, including Vietnam, Taiwan, Hong Kong, China as well. So I would say that kind of makes up the majority of the rest, along with other parts of the world that I was mentioning earlier that kind of are the second tier of interested investors in terms of numbers.
Got it.
But
Thank you.
I will say, it's interesting when working with certain families, like for instance, Indian families and Chinese families. A lot of those investors are here in the US, but we do still work with their family members who are abroad. So let's take a student visa holder. The investor may be getting ready to graduate from college, but we're talking with the family in Vietnam or China or India, and working with them to develop, as Brandon mentioned, their source of funds to get the petition ready, and then we can move forward with the petitioner to file the petition and start their process. So we certainly are working on various time zones, oftentimes regardless of where the investor is located.
Got it. Thank you for that. And Brandon, what's been your experience ever since RIA happened, EB-5 Reform and Integrity Act, nationalities, country of birth, location?
Yeah, well, 10 years ago, if we were having this webinar, 90% of the investor pool was coming from China. Then, because the demand was so strong, that it created all these lengthy backlogs from China that we're still in the process of working through. So the demographics, if we had this 5 years ago, we would be talking about this in the context of no interest from China because it would have taken too long. Now, with the Reform and Integrity Act, it created three set-aside categories of visas. And so 2,000 per year set aside for rural, 1,000 for so-called high unemployment. And I forget the number for infrastructure because no one talks about it. Maybe Christian can bail me out, but
2%.
2%, thank you. And so
Yeah.
what this has had, and also as well, adding what probably the most important feature of the Reform and Integrity Act, the ability to do what's known as concurrent filing. Concurrent filings existed for family-based petitions for a long time, EB-1, 2, and 3, for a very, very long time. Finally extended to EB-5. So what is that? That basically allows people to combine the first two steps of the three-step EB-5 process at the beginning at the same time. And what the visa set-asides plus concurrent filing has done is it's now it's opened the market to a lot more people and reopened the China market as well. So now, I think our numbers probably, if we did hard numbers with Christian, our numbers would largely track, but really the discussions have moved to, it used to be if talking to a family based in China, they would do the whole family unit, and even if one student was in the US. Well, now with this concurrent filing, because people have to be in the US to at least start the concurrent filing process, it's really changed the demographics quite substantially, and the nature of phone calls and the tactical and strategic inputs that we all have to have to deal with to make this EB-5 work as well as it should for everyone involved.
Got it. I think this kind of, I'll echo the same thing. It's happening with us as well. The biggest change I'm seeing is that we are getting direct inquiries from Chinese investors who are based in the United States.
Mhm.
I mean, I've been part of this
Absolutely.
industry for 11 years. This is the first time I'm experiencing that.
Yeah, that information is readily available for those right here in
Right.
the US. So you're going to get that direct phone call. That's right.
Yeah.
Especially this time of year, because we're dealing with H-1B cap season disappointment,
Right.
you know,
We're graduating from university.
and graduating from universities. And so you're graduating and your H-1B wasn't selected. 1 + 1 = what on earth am I going to do with myself to stay here longer? I mean, yeah, okay, maybe if you have F1 optional practical training, that buys you a little bit of time on the front end while you work out the H-1B issues. But even if you do, well, you still have the EB-1, 2, and 3 backlogs for India, China. So basically, people are now in this time of year in the early stages of realizing that not only the short, but the medium, the long-term solution to a lot of high hurdles and a lot of immigration bureaucracy problems is to basically go to the front of the line and do EB-5, which is now substantially more attractive because of the concurrent filing option.
Right. Right. No, thanks for those insights. Christian, coming back to you, it'll be great if you can tell us briefly about what does the process looks like, what's the timeline, various steps involved.
Sure. Well, wherever you are in the world, it all starts with preparing your source of funds documentation, working through questions with the project, and preparing and filing your I-526E petition. So those petitioners who are outside of the United States will be filing their I-526E petition, and that's their immigrant petition that starts the process. Now, that petition does not grant any kind of status within the United States. So you can't just come to the US based off of having an immigrant petition filed like that. You could come to the US using a non-immigrant visa if you chose to do so, but we'll get to that in a minute. So those who are outside of the US, the I-526E petition is filed, eventually adjudicated, and upon approval, you start the next step of consular processing. So that means arranging the EB-5 visa appointment through the National Visa Center in coordination with the U.S. Consular Post, the U.S. Embassy abroad, to attend your EB-5 visa appointment, where you will get your EB-5 visa in your passport and use that immigrant visa to enter the United States. And upon entering the U.S., you will become a conditional permanent resident. You're a conditional green card holder. And that green card gives you all the same rights and responsibilities as any other green card holder, other than that green card will expire in 2 years. So in 24 months, you need to be prepared to file your last petition of the process, called the I-829 petition. And that I-829 petition, the main aspect of getting that petition approved is back to what Brandon mentioned earlier, the creation of those 10 new jobs. So we all come back to Golden Gate Global and say, hey, can you provide the information demonstrating all the job creation and economic impacts that occurred using the $800,000 investment, for example? And we'll put that information all together and file the I-829 petition. That I-829 petition will take some time to get approved. We can get into those kinds of processing times if we want. But the good thing is, while it's processing, you remain a permanent resident in the United States and continue to have the ability to work and travel. And eventually, when the I-829 petition is approved, you get your non-conditional green card and you're all done with EB-5. Now, that varies for those who are in the US or enter the US while having an I-526E petition filed with USCIS. As we alluded to earlier, being in the US allows right now for some really good advantages that didn't exist in the past in the pre-EB-5 Reform and Integrity Act EB-5 world, which is that you can concurrently file your adjustment of status application if you're in the US in a non-immigrant visa status, like let's take H-1B, for example. That's a popular one. And that means that you can file your I-485 application along with your I-765 and I-131 applications, which are your applications to become a conditional green card holder. It also is an application for getting your employment authorization document and your advanced parole travel document. And so now you do have the right to remain in the US, regardless of what happens to your non-immigrant visa status. If that expires or you no longer want to use it, you can rely on being in the US based off having filed your adjustment of status application. So the steps will go I-526 petition, the employment authorization document and the advanced parole travel permit get approved, hopefully within, let's say, 3 to 6 months. I think we're all probably seeing similar processing times right now. Maybe another 12 months or so, you have your I-526E petition approved. And then perhaps another, let's say, 6 to 9 months later, the adjustment of status application get approved to become a conditional green card holder right here in the United States. You still go on to that next step 24 months later and file your I-829 petition to complete the EB-5 process. I mean, those processing times are very general. I should say, the I-526E petitions, we all know some of them have taken 3 to 6 months to get approved. Some have taken 12 to 22 months or so to get approved. And those, adjustment of status applications are completely all over the place in terms of predictability on processing times. Many are processing well over a year, but we are starting to see some improvement on that in terms of those getting approved in a little bit faster times than before. So those are the steps. Let me know if you'd like me to clarify any of that.
So, yeah, Brandon.
Yeah, and I was just say I generally give out an estimate for most people from the time you file both the 526E and the I-485 to the time that you have both approved, basically 18 to 24 months at the current time. Yeah, maybe some variants, maybe a little bit earlier, some a little bit later, but somewhere in that 18 to 24 month range. If you're overseas and you can't do concurrent filing, and if you have to, first wait for your I-526E to be approved before, you can interview at the consulate in your home country, maybe add about 6 months overall to that time, roughly. But I mean, significantly faster than what we were seeing in the past. And this has been another positive feature of the Reform Integrity Act is U.S. Congress put more firm processing time guidelines on USCIS for these I-526Es, and which, which to USCIS's credit for once, they've done a fairly decent job in trying to adhere to those processing time guidelines from the RIA. And hopefully that will continue.
Yeah, and just to build on that, I think we've certainly seen that priority processing being applied to investors investing in rural projects. I mean, that's where we've seen more consistently these I-526E adjudications within 12 months or less. But the high unemployment urban investors have also benefited to this sort of newer mandate, if you will, in terms of getting these petitions approved in a faster manner. So I agree. I think they've done a fairly decent job of following through with what Congress has asked them to do.
That's great. Yeah, it's been a long time since that happened. So I guess to summarize then, if someone's outside the United States, they wait for their I-526E approval, then go to the consulate, get an immigrant visa stamped, and within 6 months, they enter the United States and activate their conditional green card. But if someone's already here in the United States, they concurrently file for adjustment of status, they get their EAD, they have the right to live and work in the United States till they get their conditional green card. I guess that's the main difference, and then rest is the same.
That's right. I mean, and I have a client right now who just got their L1 visa and plans on entering the U.S. And their I-526E He is processing, and so they'll file an adjustment of status. So concurrent filing is for those who are filing the I-526E or already have one on file and want to file their adjustment of status while it's still processing.
Got it. And how long does it take for your law firms to prepare the entire petition, right? Because you mentioned source of funds is an important part, obviously project due diligence. So I would love to know the timelines for prep.
Oh, super fast. No, I mean, this question comes up all the time. And what I tell people, is basically you, the investor, are in the driver's seat. Christian and I are and our various teams that we're going to give you a long list of documents, and then we review those, and we're going to come back and ask for more and more after that as we put together this source of funds narrative, which source of funds is the most important aspect of anything to do with EB-5. It's the foundation from which everything else can be built upon. And so, yeah, it basically is, in the investors in the driver's seat, the sooner they're able to provide the necessary documentation, the sooner their 526Es and or 485s or whatever the case may be can be submitted to U.S. immigration.
I echo that.
Yeah.
I
Okay.
generally say, 4 to 6 weeks, sometimes shorter, sometimes longer.
Mhm.
Depends
Mhm.
on the activity of the petitioner, the liquidity of the petitioner, and ability to send us those documents that we've put through in our thorough checklist. So I think
Yeah.
it sounds like, and I do always emphasize, you're probably, most potential clients, for example, are oftentimes talking to a good set of experienced attorneys. And I mean, these are pretty efficient processing or preparation times that we're putting out there in terms of the type of petition we're putting together, a very thoroughly prepared petition. As compared to somebody who, I mean, sometimes when someone who picks this up who's not so involved in the space, you might be looking at a much longer process to get something prepared and filed.
Right.
Yeah, we've done some of these in the past in like a day or two, where the client comes to us and everything, usually US based, because the documentation is more readily available and easier to obtain and better organized, and say, hey, have the project, I'm liquid, here's all my tax returns, here's my banks, here's everything. It doesn't happen very often, but occasionally it does. And I bring this up in the inverse because I'm sure, Christian, you get this too. When we talk to people in the US, they say, oh, this is going to be really easy for you to do my source of funds because everything's in the US. And
Right.
that's the documentation. Yes, that's true, but half true. The documentation is easy. But if you're funding your EB-5 through various and multiple exercises of stock options for for your company and various different inputs, that documentation is easy, but we still have to go through your RSU award, then your exercise, then into your account and trace all this. So we had one about a year ago, which was approved, where I think the gentleman had about 200 different exercises of stock option units. And so that was this huge took up 4 pages of our brief, the chart showing all of these and the attendance Excel spreadsheet. And that was easy. Yeah, he just sold, his Techco stock. But yeah,
Right.
it was still ended up being about, 50 pages of explanation of USCIS and about 5,000 pieces of paper that went in to USCIS for the officers, who I'm sure was so happy when that hit his or her desk. But yeah, so the document. So it's not because you're in the US, it's not easier. It's still the same exact exercise. It's just in most instances the documentation is more readily available and comes to us in a better format.
Got it. I usually set an expectation for 4 to 8 weeks. Obviously, it depends on law firms and investors. I'm also glad I quit practicing law when it was still 500K. So it was almost half the work. But so again, staying with this topic of investments, right? Does the investor need all $800,000 plus fees on day one to start their process, or can they do partial funding?
You want me to take that one first, Brandon?
Yeah, take that one first, and then I'll follow on.
Sure. Well, I do get that question often, and I always start with a fully funded $800,000 filed I-526E petition is your strongest approach. I mean, that mitigates the questions coming from a USCIS officer in terms of seeing that whether the full amount has been committed through your investment, meeting the requirements, things like that. We know going in, we've documented the 800,000, and it's committed to the new commercial enterprise. That being said, filing dates are very important to people. Getting those EADs and APs, those are very important to people as well. So we do work with partial investment filings, but we handle them in I think, a very consistent and specific way, which is to say that we like to go ahead and document where the full amount will be coming from. Go ahead and put that in the initial filing, the initial brief, that explanation. Show that part of that investment has been made, part of the $800,000 investment has been made. Rely on the area of the law that says in the process of investing, you can file your immigrant petition. Make sure that on your side, Avi, that you're documenting it to show that you're accepting this investor coming in, but you've got expectations of the full investment being met in a reasonable period of time, typically spelled out with certain dates. And it's also important to get that full investment done in a timely manner, and that information interfiled with USCIS, I think, prior to the officer opening up that I-526E petition. I think it puts you in a position of strength if the officer opens up that petition. Maybe USCIS hasn't linked up the interfiling with the additional information with that petition yet. Maybe they issue a request for evidence saying, hey, this is great that $400,000 has been invested, but where's the rest of it? And you can say, look, we did submit it from the time, after filing the I-526E to the time you've looked into the file. Here's the information again. And please go ahead and approve this I-526E petition considering they've met the requirements. So, sometimes they do link up the interfiling and you don't hear back from them about anything other than an approval, or regardless, they still have questions in the normal course of issuing a request for evidence. So that's sort of the general high-level overview of a partial investment filing. Brandon, fill in the blanks that I...
Yeah, I totally agree with all that. And so, I mean, because, if coming up with $500,000 was difficult enough to do EB-5, which in the $500,000 days, I can't remember the last time we did a partial,
Yeah, they were
regional
rare.
centers and projects wouldn't even entertain partial funding, let alone loans. It just wasn't necessary. But now with $800,000, that's significant amount of money. And so a lot of people don't have that liquidity. It takes time if they need. So if they're coming from a country with currency restrictions, it takes time. Balance against, as Christian said, wanting to get on file and start accruing benefits in the timeline. Maybe you have stock options that are vesting and you want to sell, but maybe but you don't want to sell them all in 1 year because you're going to take a huge tax hit. So you want to sell some at the end of one calendar year and the beginning of the next one, whatever the case may be. That makes sense. But as Christian mentioned, if you can do all 800,000 plus everything else at the beginning, that significantly facilitates the smooth processing. Because let's just say that, okay, yeah, I have a bunch of options vesting in September 2024, and I'll sell those, and but I'll file today with 300,000. Maybe I'll take a loan, maybe not, but I know I'll have all the rest in 6 months. Well, what happens if you get a fast adjudication of your I-526? What if you get one of those 30-day or 45-day ones that we keep reading about on LinkedIn? Well, what's going to happen is you just lost control of your timeline. USCIS is going to look at it and say, okay, you said that you were going to invest the other 500,000. Let's see proof that you've done it. And by the way, you have 87 days because that's how long you get to respond to requests for evidence. You have 87 days to show this. Well, if 87 days is before your stock is vesting and you could sell it, then you have a problem.
Right.
And so if you can do it, not everyone can, great, but be realistic about your timeline. Sooner is better. And then also too, I see in the chat, I see questions about loans, which is something that's roared back. Be very careful with loans, and here's why. People forget their EB-5 history if they know it. Dinosaurs like me, who were doing this in the latter part of the 20th century, will remember that in the early days of EB-5, projects were trying all these creative loan programs, financing, promissory notes, all sorts of nonsense. USCIS shut it down very aggressively in March or April of 1998. Why did they do that? They did that for the simple reason that they concluded, justifiably so, that all these loan programs and financing and all that stuff were specifically designed to help the investor not actually invest $500,000. And so while USCIS will accept, unsecured loans, they'll accept mortgage loans as source of funds, third-party loans, whatever the case may be. Just because they accept it doesn't mean they like it. So in a year or so, when we start seeing adjudication of these things, USCIS is going to heavily scrutinize loan agreements and loan programs to look for anything like, oh, this is just set up to help the investor not actually invest $800,000. And they're going to shoot first and ask questions later. It's going to be up to you to prove that this loan or whatever was, not designed to avoid making the full investment. So, you can do it, but be very careful and expect some potential resistance and ultimate slowdown in your processing when the time comes.
And
Right.
just to build on that, so, treat it like a loan. Pay your
Right.
interest rate, pay your interest on it, keep track of that documentation.
Mhm.
Just be prepared. USCIS could ask, how are you making those payments? Did someone else give you money to make those payments? That kind of intrusive questioning.
Yeah, absolutely. And also don't pay the loan back too fast, because, in certain countries in the world where, people don't like to put money in banks, and they don't like to, declare income and pay taxes, and they keep a lot of cash. Sometimes it's been alleged, or at least in USCIS, they say, okay, and we see you took a mortgage on one of your properties and say, oh, I don't know, Vietnam, for example. And so they ask the question of, like Christian posed, okay, we sat on this file for 2 years. Please show us that you've been keeping up on your loan payments to the bank for the last 2 years. And so the investor says, oh, here's my paperwork that shows I paid it off 45 days after I took the loan. And then USCIS comes back and says, how were you able to pay off this $500,000 loan in 45 days? Well, why did you really take the loan? Did you really need the loan? What were you trying to do? And so, and that's the other thing too, is like, no one likes to pay interest if they don't have to, but don't pay it off too soon if you go the loan route, because that opens you up to potential other questions.
Right. I think it's a fine line and balance between taking a loan and not. I feel I'm very concerned about if someone's taking a loan from a regional center for the entire duration of the investment, right? Then obviously a case can be made. You never invested the 800K.
That's matter of Shun. One of the 4 precedent decisions right there. It's matter of Ho. That's exactly what USCIS shut down 26 years ago.
Right. But yeah, if you treat it like a normal unsecured loan where you are paying interest and you repay the loan in a reasonable amount of time, then of course that's your money that you invested. So just have to be careful about that. And I guess in terms of like just coming back to the topic of partial investment and etc. So I'd like to kind of summarize, and then maybe you can correct me if I'm wrong. So I guess the prescribed path is, if you are going down that route, you should have identified where the money is coming from, and you should have a certain timeline. An uncertain timeline is not your friend, because in case you get an RFE in a fluke case, then your RSUs that are vesting in 6 months can't be liquidated in 3 months to complete the investment. So I think that's really important because we have this conversation almost every day where people are taking a HELOC, they are using their RSUs, this, that, and the other. So I guess this is a very important point. Identify the sources. Just don't file a petition saying, hey, here's my 400K and 400 I'll figure out in the next 6 months.
Yeah, I mean, there are companies out there that do buy people's unvested stock options, but of course that's at a discount.
Yeah.
So,
Yeah.
you don't get in a
Yeah.
position that you have to, sell your options for 70 cents on the dollar just because USCIS adjudicated your case faster than you thought. I mean, that would be unfortunate.
I mean, the same goes with selling a property. So, you want to be able to sell that for what it's worth. You don't want to have to accelerate that sale just to keep your immigration process alive.
Right. Because then you are creating an urgency which is not even required. That was under your control.
Yeah. That was
Right.
under your control.
I guess file when your house is under contract versus waiting to sell it. And then you have that 60, 90-day timeline to receive the funds,
And,
right?
and USCIS is pretty comfortable with that kind of partial investment from what I've seen. I mean, if
Yep.
you're able to say, look, I've got the full amount pretty much committed, just need to complete
Yep.
this sale. Here's an initial amount that I've already invested, and the rest is going to follow through as I anticipate. You've got it all worked out with the EB-5 project, and it's typically completed in that time frame. You can get away with that kind of partial investment without much of a question from USCIS.
Right. And also it's a common tool, I'd say, used by Indian investors because the remittance limit is $250,000 per financial year. So yes, they have an identified source, but there are remittance limits. So they use like a loan as a bridge loan between 2 financial years. And then we pay the loan when they are able to get the money out of India.
That's right. And using I guess the fiscal tax year as a reason for making the partial investment is also something I think USCIS has been understanding about.
Right.
Say that the money's here, it's coming. I just need to get on the other side of April 1st, for example.
Right.
The remainder will then be invested and supplemented in the filing. That's another area where USCIS doesn't necessarily have to ask any questions about. It seems to make sense to them. And as long as it's all thoroughly documented, that could also avoid any kind of RFEs and get it approved.
Got it. Chugging along with, March 2022, EB-5 2.0 came to life. And so I would love to know your thoughts. Well, first, what were the changes and then how it's benefiting different pockets of investors, those changes. I'll start with you, Brandon. Let's talk about visa set aside and priority processing and dates.
Yeah, so the visa set asides, as I mentioned earlier, it reopened EB-5 as a realistic immigration possibility for investors from China for the first time since April 2017, which is when the backlogs appeared. So that's been a massive change. The concurrent filing has opened up so many more possibilities for F1s, H1Bs, and we should talk about for L1s as well, because unlike H1Bs, that if you're laid off, you have 60 days to find another H1B job. If you're an L1 and you're laid off, and we're seeing more of this on our corporate practice side, you can't get an H1B under most circumstances because, well, you have to be entered in the cap, and that happens every March. So you missed out on that. Maybe if you're Canadian or Mexican, you can get a TN visa. Maybe if you're alien of extraordinary ability, maybe you can find an O1. I mean, Australian E3, but this is a lot of maybes. And so for most L1s, if they're laid off, they have to go home and basically restart. And so, I mean, those are the real benefits, the set-asides, the priority processing, and the concurrent filing options. I mean, there's some other ones too that, for example, not every project succeeds. That's just a fact of life. And so, under the old law, a lot of times if projects failed and didn't create the jobs or something bad happened, the investor and their families basically lost the entire process. Or if they're far enough along, they were in a position, put in a position where they had to argue that they were, innocent or, had nothing, or should be let off in deportation court. Not a good place to be. It takes a long time. It's very stressful. And so the RAA did create opportunities for investors. The project doesn't quite succeed for whatever reason, to pivot their EB-5 process to another project and keep their priority date, keep everything going. I mean, it's still a somewhat untested area. I mean, we're all in the process of testing that now, so it remains to be seen how it'll actually work in practice, but at least the option's out there. And so that's another small change. I mean, we don't like to focus on the negative, but the negative does happen. And so the Reform and Integrity Act finally addressed that particular issue. Another area it addressed as well, this was a real kind of stress under the pre-RAA was, okay, well, now that the program's expired, what happens to people that are still somewhere in the process of haven't completed it? Well, the RAA has also addressed that issue by adding in a so-called grandfathering clause, which is basically if you submit your 526E on or before September 30th, 2026, then whatever happens to the program in the future, that doesn't, you're still subject to, that doesn't apply to you. You're still subject to the, the rules, regulations, and requirements of the Reform and Integrity Act, which does provide another measure of kind of security to the investor. And so overall, the Reform and Integrity Act as an investor-friendly law is a significant advancement over what preceded it. And this isn't just sales talk, but I really believe that, this is the best time to do EB-5. I mean, yeah, it's not nice that you have to invest more money than you did in the past, but other than that small little issue, everything else is so much more in the investor's favor. And, Avi, we can get into the discussion. The Reform and Integrity Act also made it more difficult for organizations such as yourselves to do business. And again, that was deliberate. That was by design to help protect the investor and make sure that the investor and their families get through this process.
Right. Thanks for that. I guess, Christian, if you could get into the actual set aside categories and, what the percentage is and what it means, like defining rural, high unemployment, etc.
Sure, no problem. So, as Brandon mentioned earlier, the set-aside visa categories were created thanks to the RIA, and no one had taken these visas up before, so that's why it opened up lines. Basically, there weren't any lines. The people who filed under these categories post implementation of the RIA are the first ones moving into those lines. So the three categories are rural, high unemployment area, and infrastructure. So you can invest $800,000 into a project, for instance, that's in a rural area, which is a place that is outside of a metropolitan statistical area and has a population of under 20,000. So you'll have the project will have done its due diligence and looking into making sure that census tract or that county is a rural county. That making that $800,000 investment is going to mean that you can be issued one of these set aside EB-5 visas, or your conditional green card will be issued under this set aside visa category. Same goes for a high unemployment area, which is in an urban area. And if that census tract or an adjacent census tract to the project site equals 150% of the national unemployment average or more, then you can qualify for one of these set-aside visas as well. So, 20% of the overall 10,000 visas issued each year are set aside for rural investors. 10% of the overall 10,000 EB-5 visas issued each year are set aside for high unemployment area investors, and then 2% granted to those who are investing in to infrastructure projects, although we have not really seen that be an active area of EB-5 yet. So that's how those set-aside visa categories are characterized and work, and why it is that no one's taken up those visas until now, because there wasn't an opportunity to make an $800,000 investment in a rural area that was given the opportunity to take this set aside 20% of the overall EB-5 visas issued each year.
Yeah, that's absolutely right, because the purpose, back when Congress wrote the original EB-5 law back in 1990, Congress intended for EB-5 investment to go into, manufacturing and also rural areas, neither of which happened at all
Yeah,
right.
over the life of the program. And so
It went to
that's,
New York.
it went to, yeah, it went to West 57th and Street and 6th Avenue in Midtown West. And yeah, which was not what Congress intended. So these set-asides and the process and the mandated processing times attached to those are deliberate attempts by the U.S. Congress to force more EB-5 investment into rural areas. And also should mention too is that, yeah, these not only these 2,000, 1,200 set-aside visas reset every year, but if USCIS and the Department of State, let's just say for this government fiscal year, they only issue 1,000 visas for rural filings.
yeah,
Okay, so then next year, we start off with 3,000, the 2,000 that we start off the year with, and the 1,000 rollover that were not used the year before. So that is very nice as well, because that keeps potential backlogs down, more people can do it. And, it also further drives investment toward rural areas.
and that rollover of unused visas is part of the Reform and Integrity Act, which is
Yeah.
thanks to that. So, and we should say that these rural areas, I mean, you're not necessarily looking at projects that are completely out in the middle of nowhere, or places that you've never heard of, I should say. I mean, I'm not the project guy here, but a lot of these places are pretty familiar areas to me that I'm thinking, wow, I didn't realize that was that low of a population. No wonder it's so beautiful. There aren't that many people around. And include in the high unemployment area projects. I mean, you can still find areas right here in Houston where I am that qualify as high unemployment, that I'm thinking that seems like really good businesses are located there. But the unemployment rates just happen to allow for that project site to qualify. So I think that it sort of landed in the right place. I think, to Brandon's point, I think investment is likely going into more areas where Congress originally intended. But as on the project side, you're still able to find, I think, projects that you're comfortable with.
Right. I think a lot of investors, when you talk about rural projects, and I'm from India, right? When you talk about rural India, it's very different from Napa Valley or Sun Valley, Idaho, right? So when you are talking about rural with international investors, they're like, how are you able to get an EB-5 project, middle of nowhere, no infrastructure and whatever? And well, like one of our projects, Sun Valley, the penthouses in that town are for 5 or 6 million. And this I'm talking about 3-bed, 4-bath, or 4-bed, 3-bath, right? So these are not economically backward places. It's just that it's a population play, right?
Yeah, we were in India on one of the Trade Association roadshows, I think 2 years ago this month, and I was moderating a panel with 3 or 4 project people, and I think we're in Delhi, and the project guys are talking about how awesome the rural projects are and everything, not looking at the audience of looking back at them with absolute sheer horror and panic, like, oh my God. And I'm like, guys, you have to put this in a little bit more. You need to explain this better, more context. Like, we know how great Napa or Sun Valley, Idaho is, but and I think that's starting to, industry starting to, rural in the US doesn't mean grinding 14th century levels of poverty, as it may mean in other countries where
Right.
EB-5 marketing is is quite well developed.
Right. So moving to motivation of people in various, stages in life, various
Mhm.
visa categories. Let's start with H-1B professionals. What are some of the common reasons why your investors, your clients, are filing an EB-5 petition? I'll start with Brandon and then go to Christian.
Yeah, so the H-1B visa is great. 20 some odd years. It used to be if you didn't receive your green card in 6 years, you had to leave. Congress changed that law in the year 2000. So, if you were stuck in the green card process, you could renew your H-1B, theoretically forever. Well, that's great. But actually, no, it isn't, because in order to qualify for that, you have to be stuck in the green card process for, indefinite period of time and subject to restrictions on the H-1B. So because of the, grinding and internal backlogs and for EB-2, EB-3, and to a lesser extent, EB-1 India, and sometimes for China as well, EB-5 becomes the solution because, you just can't keep renewing your H-1B forever. You're in a perpetual state of basically getting nowhere in your life. You're established here, your kids are here, but you pay taxes, but you're not really, you're not really a full resident, and you won't be for a very, very long time, if ever, because of the way that the current EB-1, 2, and 3 system is. And then we're starting to see, because of that, Christian, I'm sure, talks to people. I talk to people. I spoke to someone yesterday. Yeah, I've been on H-1B for 11 years now. Like, that's absurd. That's ridiculous. What's your priority date? 2016. Well, you're going to be on H-1B for another 35 years if you don't do something about it, at which point your children will have long aged out. And so this is becoming, it was great 2-3 years ago when the tech companies were just hiring people left, right, and center. On the corporate side, we would get guys that had 10 offers to go work for various tech companies. Well, guess what? They overhired. They're all shrinking. They're all laying people off. And their children are not getting any younger. So you add all those factors, and they want to do other things. They don't, working for bigtechco.com was great for 5 years, but now their ambitions to do something else are stymied until they break out of the H-1B system. Again, EB-5 addresses all that, and helps get the children green cards so they don't age out, because let's face it, if you've been on an H-1B for 11 years and your child's 13, well, in 5 years you're still going to be on H-1B, or in 8 years they're going to have to face an issue of getting their own independent visa status or going back to a country that they probably don't even remember living in on their own. And so again, EB-5 concurrent filing provides a solution to all those issues.
So
Or even for that,
please go ahead, Christian.
and just real quick, building on that, even for that family where the children may have been born in the US, now you have US citizen children, and you're relying on an H-1B for the next, consider, but maybe you have very young children, for the next 18 years or so. That, and you don't know if your job security is there or not. You're going to move back to your home country at this point with your U.S. citizen children. That again, that's where EB-5 comes in to help out families.
Yeah, I guess it's job security, certainty of living in the United States, but now we are seeing increasingly, as EB-2, EB-3 backlogs go on, it's about keeping the family together, right? And this is close to home for me because my own nephew was aging out and my cousin filed for EB-5. So I'd like to know from you, at what stage does the child's age gets locked in? When can parents be sure, hey, my child's 18, he'll remain 18, he or she, till I get a green card? Either one of you can address that.
Okay.
Yeah, so basically you can make a very, very, very strong argument. There are some out there in the community who disagree, and and that's perfectly fine. But my opinion is once you file the I-485, then that's it. You're locked in forever.
Got it.
Yeah. And
This
the
is very-
I-526E petition, that immigrant petition locks it in first, but as you know, we know the it's about the next step, whether you're adjusting or consular processing, of trying to keep the age frozen beyond I-526E approval. And if there's a severe backlog, that could create an age out issue where the children's age unfreezes again. But the big advantage for those in the US is being able to file that 485, back to what Brandon said.
Great. I think this child aging out issue has also been resonating with a lot of E2 visa business owners, right? So apart from children aging out, what are the other reasons you've seen, Kristen, this is to you,
Okay.
entrepreneurs looking at EB-5?
Yeah, so E2 is a great visa. It's a non-immigrant visa, and children can be dependents on the E2 with their E2 dependent visas until they become 21 years old, and then they can no longer qualify as a dependent on the E2. So I have clients come to me say, it's time to file my EB-5 case. I want to keep my children, here and steady with their school. I don't want them relying on an F1 student visa for too long if they don't have to at all. Let's file the EB-5 case and get them going to school based off even their adjustment of status processing. And so that means that regardless of them turning 21, they can remain in the US, and now they've got their own immigrant process piggybacked onto the petitioners. So that's one reason we see E2 investors move forward, E2 visa holders move forward with the EB-5 process. The children are getting close to that age of 21 and they want to stay here as a family unit. And also, just continuously relying on that E2 business can be tough. You've got to renew that every so often, and that can be fairly often depending on where you're from. Not all E2s are the same, right? Because of the visa reciprocity tables, depending on what country you're relying on your E2. It could be every other year that you're having to renew it, or every 5 years, but still you're relying on a business at that point being profitable enough, being active enough to be able to renew that E2, and you might not want to hold on to that business any longer. And so now you're thinking, I just want to be done with this, get my green card, become a permanent resident, maybe go on and apply for citizenship, and I can enter into whatever business activities I want. I'm not beholden to being here just based on this one business that I'm active in. So those are two of the main reasons I see for CE2 visa holders getting into EB-5.
Got it. Brandon, I'll get into some other green card categories, and I'll request you to address how different or difficult it can be compared to EB-5 to get them. So I'll start with EB-1C for international managers and executives.
Yeah, so the EB-1C, as I like to say that so over the last few years, as people try to primarily chargeable to the India quota are getting sick of the EB-2 and EB-3 backlogs, kind of came up with the idea, well, I'll just have my company transfer me to Timecodes Canada for a year, and then I'll come back and I'll be a L1A. And then, so I'll get another 7 years of that. And then because of that, I'll get an EB-1C, and, I'll move up the table substantially. As I like to say, because we have a very significant non-EB-5 corporate practice, I mostly see this happen on LinkedIn, the Wall Street Journal, Forbes, and Bloomberg. Kind of out in the wild, I rarely see it. Why do I see that? So you get a call from someone at the mobility department. Hey, our employees are tired of waiting, so let's work through the exercise of transferring up to Canada and transferring back in a year later. So, okay, sure. Well, you're gonna have termination costs in the US. Then you're gonna have to pay Canadian counsel to get them, ICT, intercompany transfer visa in Canada. And then you're gonna have to, pay relocation to get them up to Canada. And then you're gonna do it all again in 12 months. What do you mean? Well, then you have to tell your termination costs for tech in Canada, whatever the labor and employment laws are, pay your relo vendor again, and then pay me, which is the part I like, pay me to do an L1A. Oh my gosh, well, start working through that. And it's, suddenly the manager and the global mobility person are not as enthusiastic anymore about these, 12 to 18 month, visa runs up to Canada and back, because it's a significant expense to do all that. We're talking probably, with the relo, 150, 200,000. What, so you can get an earlier priority date and quit the company sooner? It just doesn't make any sense to these companies. And then if like they do it for one person, depending on the size of the company, then they have 100 people in line saying, hey, well, you did it for Christian. Why can't you do it for me? And so, I mean, it does happen, but it's very, very rare. And it's not a strategy. It's not a strategy at all, because, I mean, yeah, while you may be able to port your EB2 or EB3 priority date that's been sitting there forever to an EB1C, EB1C for India and China periodically backlogs as well. And so it doesn't really, I mean, it's helpful, but it's not a solution, even if the company is willing to do it for you. And overall, the approval rates for L1As and EB1Cs are significantly lower than 526s and 829s.
Got it. Christian, any thoughts there? Also, in adding context about new office L1s and expanding business in the United States?
I mean, I thought Brandon painted a very good picture of the various issues that come up, but the L1A new office, for example, is not an easy endeavor. Dealing with USCIS on those, while doable, not a high percentage. It may take several attempts. You really need to get a business pretty far along to even qualify for an L1A new office. It's also just getting you 1 year. You then have to extend it for another year. It's going to be a long and windy road to turn an L1A new office into a green card in the long run through an EB1C, for example. Depending on your resources, I mean, if you have them,
Right.
EB-5 is such a more, in my mind, predictable, and now, thanks to the processing times, I would say speedy process.
Yeah, absolutely. So, I mean, in an overseas context, like, the go to Grenada and buy a Grenadian passport and come to the US and E2, that market's been shut down.
Right.
Fine. But there's still kind of a residual in overseas. So I'll do L1 because that'll be quicker, cheaper, and easier than doing the L1. And yeah, it might be quicker at the beginning because of the premium processing that's attached to the initial L1A. But it's, if you, as Christian was alluding to, and you're alluding to the new office, it might not be cheaper, because when USCIS is approving a new office L1, they want to see that basically that you have a credible idea that's well capitalized that you can execute on. The US government's not going to hand out L1A visas and hope for the best that you succeed. They want to see that you thought it through, and that requires an investment and requires employees. And so, I mean, maybe you can do enough to get the initial L1A approved, and like Christian's client immediately come to the US and do EB-5. But that's more, maybe that works in certain tactical situations, but that's more money. So
Right.
in order to do an L1A new office, right, a lot of times the cost savings relative to EB-5 is not very much. And there's more hurdles you have to jump over, more hoops you have to jump through, all of which have lower approval rates. So it might be faster initially. It might be cheaper in the long run, but it's certainly not easier than EB-5.
All the while, you've got to keep that foreign business running.
Oh, yeah, that's true.
Yeah, that too. Yeah. Small little detail, but
Yeah.
yes, important one nonetheless.
So I'd also like your thoughts on national interest waiver. We get a lot of Brazilian queries and they're weighing their options between an EB-5 and an NIW. So do you have any thoughts about that?
Yeah, people need to stay off of LinkedIn and WhatsApp is the sarcastic
Yeah.
answer.
I mean, I think that there are certain types of professions that perhaps are being I don't know, I don't like using this word, but abused or overly a little saturated in the types of petitions that are being filing. I don't. I mean, I don't. I. Why do I think that? Because I just hear from the different inquiries that I get, and there are certain professions that I'm just like, I don't even think you should consider it right now.
Mhm.
We do have a solid NIW practice, and that's because we are pretty picky in terms of what we're willing to file for that category. I mean, unless we're just warn a client up and down that this is not a strong petition, and if they still want to try it, that's fine. But we tend to be pretty selective, make them put together a very robust resume before we even take them on as a client, so we can review that resume and even and tell them whether it has a shot of making it. So yeah, I mean, I know that there's sort of been a cottage industry. It seems to be that, oh, why would you try EB-5 when you can do something that's focused on your experience and your expertise, and it's apparently a lot cheaper, but I think the predictability goes out the window. And I think you just have to be careful about what you're presenting. You always need to be straightforward about what you're presenting, and I don't necessarily know what those petitions look like.
Yeah, so I mean, for hypothetically, for example, if like you're, let's just say you are a drone designer that has military applications, that might be in the national interest. Or you have some sort of, I don't know, doing some, working on, I don't want to say lab grown meat because that's certain, but let's just say that whatever it is that you're doing has to be in the national interest of the United States as a whole.
Atmospheric scientist.
And thank you. Absolutely. Outstanding. My dogs totally agree. So let me go on a moment.
Um, so I mean, we are on to our last 5 minutes of the webinar. I would love to know, like, do you have any thoughts on how to avoid RFEs or common pitfalls, or just any words of wisdom for prospective EB-5 investors?
Yeah, I'll start. I mean, I think right now, USCIS tends to be focused on, I mean, beyond just the sort of typical items you want to make sure you're documenting. But I feel like USCIS really wants to see that once they're handheld through the maintenance and tracing of funds, and how they get to the United States, or if they're in the US, how they've gotten into the project. So what I mean by that is, I mean, we always want to really show a strong kind of source. Here's obviously where the money was made, but they've gotten, I feel like, a little more fixated on that tracing from bank account to bank account, or seeing a $20,000 deposit pop up in these bank statements, which I've always been careful about, but I feel like USCIS is even more interested in knowing and making sure that this little piece of funding doesn't affect or really go into that $800,000 investment. Diagrams, charts, very helpful for USCIS. That I've seen. I've seen them get really interested in making sure that that's part of the petition. But maintenance of funds, I'd say, just showing them, really going that extra mile to show, yes, I bought and sold this property. Any good experienced EB-5 attorney is going to know to get to document how they had funds to buy the property, or explain how they had funds to buy the property. But then let's show how those funds were maintained over the years and now invested into the project. So that part, I think USCIS is buckling down on.
Yeah, I would agree with that. And I would say, you know, one of the sayings as I have is that there's no bonus points for creativity in EB-5, only the creation of avoidable headaches. But that doesn't stop people from being creative. And, I mean, we addressed the loan issue. Some were, more creative than others. Some will be scrutinized more or less than others. But when you start getting into like self-directed 401ks and crypto and stuff, you're asking for problems because USCIS gets thousands and thousands of these. And so they have their, they get fixated on things, as Christian mentioned, they have their pattern and practice, and they see a lot of these. And so they're used to seeing things a certain way. So if you give them something new and different for the purpose of being creative, you've given them something new and different to think about. That's not good for you. That's, that's what their first instinct is, gee, what do we do with this? Well, let's put them all, let's put them all in a file room until we figure it out in 5 years, which is exactly what we found out has happened to all the crypto cases. Not many of them, but pursuant to Freedom of Information Act litigation, basically USCIS stuck them all in a room in 2021, and they're just sitting there until they figure out what to do with them. So, source of funds, again, the pillar of all of this, source of funds is really about two things if I boil it down. The credibility of the story of how you earn the money and the ability to document it. It's as simple as that. And so, if you can't do one or both, becomes an issue, and then you have to work with your attorney to figure out something credible that you can document. And if you can, and it's kind of, nothing too out of the ordinary, then that significantly reduces your RFE and, notice of intent to deny risk going forward.
Right. Thank you both. I think it all comes down to keeping it simple with EB-5 and predictable. And I guess quick recap, partial investment is okay. Rural doesn't mean middle of nowhere. And as long as you have sites on the funds and you can document them properly, it doesn't matter if it's a loan or a gift, if it's earned in the United States or overseas, it all works for EB-5. Lastly, if you would like to share your contact details, Brandon, Christian, your emails, etc., you can say it out now, or we'll also share the recording with our audience.
Sure. So my email is Brandon, BRANDON, at meyerlawgroup.us, MEYERLAWGROUP.us. So Brandon at meyerlawgroup.us.
And my email is the very easy email of ctriantafyllis@jw.com. So hopefully you can see my name in the chat.
Spell it out for us.
At jw.com. I've done that plenty of times in life. I'm not going to do it on a Friday for everybody out there, I'm sure.
Okay, maybe we can drop it in the chat too, just in case.
Yeah, go for it. And I can be reached at alohia, ALOHIA, at gggfinancial.com. All right, everyone. Thank you so much for attending, and thanks, Brandon and Christian. I'm sure our attendees gained a lot of knowledge listening to you, and they'll obviously reach out to you if they have any queries.
All right.
Thank you for the invitation. Have a good weekend, everyone.
All right.
Talk to you soon.
Cheers.
Thank you all.